you are liable for the amount here. You can't even get to court. You have to call by telephone. And
yeah,
so,
this is why our country works great. Because Cindy's using my car.
Welcome back to Court Rumors, where legal drama hits harder than a gavel. Today's case, buckle up. Bradley Roberts is facing off against Liberty Mutual over a $10,000 judgment tied to a tangled mess of car ownership, no insurance, and a disappearing defendant. From missed hearings and finger-pointing to contradictory defenses, this hearing is a full-blown wreck. Roberts claims he wasn't even responsible for the Cras and blames someone named Cindy for everything. But with no proof, no affidavit, and a judge who's already heard it all, things go from bad to worse. Will Roberts talk his way out of a default judgment? Or has the court already made up its mind? Stick around, because this one's got everything. Emotional outbursts, legal confusion, and one of the bluntest judge reactions we've seen in weeks.
74809 for the record.
and Mr. Bradley Roberts is here by telephone only.
Yes, sir.
All right, this is a claim by Liberty Mutual Personal Insurance Company versus Bradley Roberts. And this has had a bumpy ride. We've had a couple of previous.
Here's where the case starts to spiral. Roberts admits there was no insurance on the vehicle at the time of the crash. The judge references a maze of people connected to the car: Cindy, Jessica, Xavier, and not a single police report in sight. It's a textbook example of how messy things get when responsibility is passed around like a hot potato. But what really stands out is Roberts' failure to comply with court procedures' no discovery responses. No proper attendance and no legal backing. This isn't just a procedural hiccup. It's a full collapse of his defense from the inside out.
No police report was filed, and so all these facts were raised, and so they continued the matter for 90 days for additional discovery. Mr. Roberts didn't show up. We continued the matter to March 31st, 2025, and Mr. Thomas Duquette was here. So we adjourned the matter for 90 days for discovery, and the defendant never complied with any of the discovery. So he didn't answer any of the plaintiff's requests for discovery, and he didn't show up for the court hearing. So Mr. Duquette moved for a default judgment. $10,415 in costs, in damages, $232.13 in costs, and a $75 attorney fee. So a judgment entered by default on March 31st.
Which should have never happened. You heard me say she jumped in it and started it and put it in reverse. She took control of the vehicle. It was hers, not mine. She's using mine to go to work right now, or I'd have a ride there.
Okay. Well, you didn't show up for the hearing. That's not her fault.
And I paid someone that day. And they didn't make it to come and get me, and I walked home from work to make sure I got on the Zoom. I'm sorry, but this is making me mad. I shouldn't even be here.
Well, that's open for discussion. You think you shouldn't be here. They have a different idea about
exactly.
Well,
because the insurance vehicle, they assume responsibility.
Do you have a legal citation for that? Or is this something you read on the back of a cereal box?
And this right here is the moment the judge slams the brakes. Do you have a legal citation for that, Tor? Did you read it off a cereal box? That's not just a burn, it's a wake-up call. Roberts is clearly overwhelmed, admitting he doesn't understand the process or how to respond to discovery. But here's the legal truth. Ignorance of the law isn't a defense. Courts require you to play by the rules, whether or not you understand them. At this point, the judge's frustration is boiling. And we've got to ask, should people be allowed to represent themselves in civil court without legal training? What do you think?
Attorney, because no one would take the case.
Yes, it's a tough
I'm tired of
situation.
getting ragged on when I'm trying.
All right, well, all right, you may be trying as hard as you could. Maybe you could spend $50,000 for a lawyer and the no-fault statute still applies. So anyway, you don't respond to the discovery. Everything you're telling me, this isn't how the legal system works. You show up and say, hey, Judge, this is all a big mistake. Sorry, here's what really happened. Please dismiss it so I can go home.
What they're doing.
Well, they filed legal pleadings.
That should have never happened.
They're here to provide testimony regarding the matter. In fact, we took some testimony, or at least some legal representation, on March 31st. So anyway, you don't show up on March 31st. The judgment enters a few days later, and you file a motion to set aside the default on April 14th. Which it was in 21 days of the default setting aside. So when you move to set a default aside, there's a certain standard you have to meet. You're supposed to file something called an affidavit of meritorious defense, and you're supposed to show good cause for why you did not appear for the hearing. So in your motion, which you filed on April 14th, I'll just read it. On March 31st, a person who lives with me borrowed my vehicle to look for a job. I totally forgot. Although I called the court around 8:05 and left a voice message as I was going to be late because of no ride. So I walked a couple miles, got a ride. Then when I was home and on Zoom, for some reason, my tablet would not work, the microphone, no matter what I did. I have a meritorious defense for this claim. I, Bradley Roberts, and Keith Ryan, seen Cindy Vandergriff, also who own a 2005 GMC Envoy. Cindy got in the vehicle and started it and then reversed it, which in turn slammed into the plaintiff's parked vehicle, knowing the vehicle had no insurance. Therefore, knowingly take possession of said vehicle, the plaintiff then left the scene. No police were called. And someone later gave the plaintiff an old insurance card which had my information on it.
Correct.
Which is different than what you told me at the hearing back in December of 24. So I'm not sure that establishes an affidavit of meritorious defense or a legitimate reason for not coming. I don't have any notes in the file that you called. I don't say that you didn't. The hearing was at 8:30. At any rate, I called the hall and checked around and you weren't here. So having laid the premises out, Ms. Palmer, what's your position here?
Our position is that the defendant has not met the statutory burden in order to set the judgment aside. As the court has indicated, the information he provided as to his failure to appear for a court-ordered hearing, it doesn't rise to the level of good cause, but obviously the court is the gatekeeper of that. But our position is that it does not rise to that level. And then the meritorious defense that was advanced, it is not necessarily consistent with what was originally indicated. And this could have been helped if the defendant had answered the discovery. So right now we're not exactly sure what the defense is. And although I know the courts are somewhat liberal as it relates to advancing a meritorious defense, this is an affidavit. So I couldn't even necessarily use this statement if the court was inclined to set aside the default judgment to impeach him or to have him basically attest to these facts. So he could theoretically change his version after this point too. So we believe that he has not met the statutory requirement to set aside the default judgment at the bare minimum.
Let me see if I understand.
This is the hammer drop. Despite all his efforts to shift blame, Roberts finally admits he was the insurance holder. That's the critical fact the judge was waiting for. It's the legal linchpin. Whoever holds the policy shoulders the liability, especially under no-fault laws. Whether Cindy drove the car or not becomes irrelevant when Robert's name is on the insurance. This is why documentation matters. Roberts thought handing over a phone number would absolve him, but that's not how court works. If you're the named party, you're in the driver's seat, legally speaking.
Yep, I was. That's what started all this, because someone got my information.
Yes.
So, Your Honor, and I'm not sure if this is the right way to do this, but I was confused in what his defense was here. I thought he was saying it was a vehicle that looked exactly the same as his vehicle that was completely separate. So he's saying that someone got into his vehicle and then drove the vehicle. Is that what this defense is here?
Yes, she got into her 2005 Envoy and, yes, drove the vehicle.
That you were the insurance holder on.
Well, used to be at that moment, though, and she knew there was no insurance on it because it had lapsed. I wasn't driving it. It was parked.
Your Honor, based on the defendant's statement, and I understand he's not under oath, so I misstated maybe in how I responded to the meritorious defense. But if he was the title owner, registrant, or constructive owner of the vehicle, he's still legally responsible for whoever's driving the vehicle if they had permissive use.
Yes, he doesn't understand. But his argument is...
But then when she jumped in it, yeah.
She drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandigrift is the owner. I borrowed it because she wasn't driving it, so I insured it. Then I quit driving it, and it was parked. Cindy Vandigrift's still the owner. And then Cindy Vandigrift
day, all we know about that is what you're saying here, and you're not under oath. You never filed.
Right, and I'm saying call her and she'll tell you all.
That isn't how it works. They sued.
Well, it should have been, because I shouldn't be here getting upset, and you shouldn't have to deal with me.
Well, I wish it were true.
Yeah, I know. Okay.
All right.
I'm sorry.
So they send you a bunch of documents to ask you these questions. Who's the car registered to? Show me the title. Who was your insurance carrier? When was it insured? You didn't answer.
How would I have the title if I don't own it? So I have no idea to fill this stuff out. No idea how to do it.
So all you have to do is show up and say, hey, I don't own this. I don't have any proof that I don't own it, but they're showing that you're the insurance.
I did that the first. Wouldn't that be the first meeting we had when I left them her phone number and contact info? It would have been taken care of. If they would have followed through and said, okay, you're not the owner, I'm going to call this number, they would have found out who the owner was legally.
All right. Anything
I can
further?
get on Michigan website and do that.
Your Honor, just in response to this last argument, obviously it's not appropriate to somehow switch the burden to the plaintiff by saying that we were supposed to call and then I guess somehow add her to the lawsuit. We don't have anything definitive to even be able to sue Cindy upon. Maybe if he answered discovery, maybe if he had sworn statements, any of those things. But he just has his versions that he is, advancing that we cannot rely upon. But I didn't understand. That we cannot rely upon. So that's why it was critical, and that's why the court opened discovery and allowed us to have discovery for him to answer discovery. That's why it was important. And if he didn't know the answer to a question, because that he didn't know, it's plenty of questions on here. I think 12 interrogatories, 5 requests for admissions, and a request for productions, I believe. So it's quite a few questions on here. First one being his name. And I didn't understand how to.
Mr. Roberts, you point out a good and valid point.
And this moment captures the judge's bigger message. You're not in small claims. Court you're in general civil court. Translation, this isn't a traffic court. It's a high-stakes arena where legal knowledge, documentation, and deadlines matter. The judge isn't just ruling against Roberts, he's warning every viewer watching. Drive without insurance, and the consequences can chase you long after the crash. It's a brutal but necessary reminder of how civil liability works. What's your take as the judge being too harsh? Or is this the wake-up call defendants like Roberts need?
And you're in the weeds, all right. You barely filed an answer. You didn't show up for the hearing. You didn't answer any of the interrogatories. And you haven't shown an affidavit of meritorious defense. And I'm not sure we have good cause for why you weren't here. So your motion to set aside the default is denied. Good cause and meritorious defense were not established. Now, you can sue her if you think she's more liable. She doesn't have any money either, and I doubt they're going to get any money out of you. But 100.
When she jumped in it and started it, isn't that taking for the known possession of the vehicle back?
No, it's not. It's not.
Okay.
No, it's not. All right, I'm going to send you an order denying your motion. And if you want to appeal that further, I guess you're welcome to do that. But for the reason stated, you are liable for the amount here. You can't even get to court. You have to call by telephone. And
this is why our country works great. Because Cindy's using my car. I said that.
Sorry about Cindy using his car, but that isn't going to go very well forward. But for all the reasons I stated, he didn't show up for the hearing. He didn't answer the interrogatories. He didn't show necessarily good cause for why he wasn't here. He didn't file an affidavit of meritorious defense. He filed he said two different things about what actually happened, none of which was under oath. And he just doesn't understand, and he'll be mad no matter what I try to say. So this is another case of it is what it is. And
in the end, Judge Middleton denies the motion to set aside the default. Why? No affidavit of defense, no good cause, and two different stories that don't match. Roberts leaves with a $10,000 judgment and one hard-earned lesson. Owning or insuring a vehicle means owning the consequences too. As the judge said, don't play fast and loose with the rules. And now, it's your turn. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe. For more jaw-dropping courtroom breakdowns only here on Courtroomers.